Good afternoon and welcome to Confirm NYC conference and virtual meetings and ephemeral messages should we preserve and what if we don't. The session is sponsored today by Archive 360. Archive 360 is a leader in intelligent information management. Their software platform is trusted by more than 2,000 of the world's most security-conscious businesses and government agencies to securely migrate their digital data to the cloud and responsibly manage it for today's regulatory, legal, and business intelligence obligations. Increasingly, customers use their platform to retire their legacy applications while still retaining the data, secure their data, and access it in the cloud and control redundant, obsolete, and trivial content with defensible disposition. And now it's my honor to present the speakers of today's session. Ron Hedges is a senior counsel with Dentors US LLP. He serves as a United States Magistrate Judge in the District of New Jersey for over 20 years. Ron speaks and writes on a variety of topics, many of which are related to electronic information, including procedural and substantive criminal law, information governance, litigation management, and integration of new technologies such as artificial intelligence, blockchain, and telemedicine into existing information governance policies and procedures. Among other things, Ron is a co-author of the Pretrial Practice and Discovery Committee of the ABA section of litigation. And our next speaker today is David Smythe. And David is a principal for financial services and information governance and digital solutions at Iron Mountain. He brings over 20 years of financial industry experience, having developed global information governance program, e-discovery, data protection, and banking support functions. Prior positions involve strategic planning, program development, and operations normalization for structured data preservation and e-discovery. It is my pleasure to kick off this session to our speakers, and they would be happy to receive your questions, and they will try to address them throughout presentation. So with that, I hand it over to Ron and David.
Thank you, Anna.
Thanks, Anna.
Good afternoon, everyone. Thank you for being with us today. Let's start with the obligatory disclaimer. But before that, David, any opening thoughts?
Yeah, just a quick comment. I have a feeling that lots of folks on this session know you, Ron, pretty well. Ron is certainly going to handle all the legal perspective here from, at least as far as I'm concerned. And I would say that I'm bringing an IG practitioner's perspective with certain industry experience. And certainly as these technologies have grown and changed so rapidly over the recent period that it's hard to, at least it's been hard to keep a full handle on all of the changes that are happening in the developments, but hopefully we'll give you a flavor of that along with how to manage this from an information governance perspective and certainly cover the legal concerns as well. So thanks, Ron.
Well, let's start with the disclaimer, David. We have to do this. So the information in these slides and the presentation is not legal advice. Please don't consider it to be. This represents the personal opinions of David and myself, presenters. And in addition, this is being offered for information and education purposes only. And with that, let's talk a little bit about the topics. Unfortunately, we're still in the grips of the pandemic. I think it's fair to say we would all like it to end tomorrow, but it's not. And David, it's probably worth your thoughts now or later as to where you think we're going to be when the pandemic is over, or at least sufficiently under control that we don't have to use ephemeral messaging platforms and virtual meeting platforms. But let's look at the topics. We're going to be defining IM. and virtual meeting platforms. We're going to talk about the risks and benefits of using these. We'll look at some case law and guidance. And then, David, you're going to focus on information governance strategies. But, David, what do you think is going to happen, say, in 6 months or a year? Are we going back to the way things used to be?
I think there's going to be a mix, frankly, and it depends on where you are and possibly what your industry is. I know already that some of the clients I have in the financial industry are already heading back into the office for a number of reasons. Then again, there are a number of companies that have already announced consolidations of space. So I think that certainly there have been decisions made where the virtual meeting platforms are here to stay and will continue to be leveraged significantly. I think the ephemeral messaging has its place in the work that we do, and I'll share some information about that. But in terms of maintaining these technologies, I think they will continue to be a significant part and possibly a growing part and a changing part. And you'll hear a little bit about how some of these capabilities are changing. We'll talk about that in a minute.
If you look at all of the legal news these days, I think you'll see that we're doing a lot of depositions and meetings through these different virtual platforms. I don't know if that's going to change when we're back outside of the pandemic. For the simple reason, I expect a lot of corporate entities, whether they're public or private, are going to be looking at the benefits of using virtual meetings instead of flying people from one part of the country to another for a meeting. Depositions, the same thing. Depositions over the telephone always existed. They were relatively rare. We're seeing more, well, obviously we're seeing all of that. I expect we're going to see a mix, just as you mentioned, David, as to what's going to be happening. Trials, hearings, and the like. I've seen announcements now that there may be some trials starting in person, starting in another couple months. We'll see how those go.
And hopefully the facility with using these tools continues to grow. And fortunately, the ARMA Metro New York City chapter has chosen Socio, which so far has proven itself an excellent app. And hopefully neither Ron nor I will turn into a cat during this presentation, right?
I have no animals next to me to make noises on the screen or the like. And we laugh at that. But when you're appearing before a court or when you're at a important meeting, having those distractions may not be the best thing. And then depending on who the distraction is, there may be problems with invading attorney-client privilege, for example, loss of confidentiality of information and the like, which is beyond, in a sense, what we're talking about today, David, but we still need to think about the environment we're in and who's listening in, which means we're not talking about competence today, but anyone who's setting up these platforms and using them has to understand the platforms and their capabilities and limitations. So, David, I don't know if you have any thoughts about that, about what you look at when you're choosing platforms, other than what you might talk about later.
Certainly. And again, I think it depends in part on the industry that you're working in. Certainly, there are industries that are more highly regulated where you might have some limitations. There are industries, again, I'll mention the financial services industry, where companies have bonded together and created applications, and I'll mention that in a minute, in order to facilitate the communications and facilitate trade, for instance. And certainly there are geographical concerns. So yes, I think there are legal, regulatory, and business rationale for choosing certain tools. And of course, as we've just heard in one of the presentations, some of the capabilities of the big players, the Microsofts, Googles, et cetera, are going to have an influence depending on the platforms that your company decides to run. So certainly there are lots of drivers that will make decisions for your organizations.
Well, let's take a look at the definitions. Ephemeral messaging, pretty simple. You see the two key characteristics. automated disposition of messages, which may or may not be happening. And then we have this encryption functionality that, David, I guess it's fair to say that can be good or bad. If two salespersons want to communicate about something, there may be a reason why some supervisors or IG personnel want to know what the communication's about, isn't there?
Absolutely. And there's lots to be said about encryption. I think right now, from a social perspective, I think there are people who embrace that. From a business perspective, I think we get into much more challenging discussions about what an organization needs to be able to know, what happens when you get into a legal matter and production. And we might touch a little bit on what the big carriers have to deal with as well. Um, some of the folks here may have heard about some of the challenges to some of the big carriers or technology providers where government agencies are essentially trying to force some discovery on organizations that have simply said we either can't or we won't because of privacy concerns and so forth. So we'll talk about that a little bit more.
And then, I'm sorry, go ahead.
Go
And
ahead.
then we have virtual meeting platforms. Pretty simple. We're on one now. It's just a platform that lets you communicate a multitude of people virtually real time or in real time. And you'll see some of the names of the bigger players in the field. And with that, David, why don't we talk about messaging in general? I'll turn it over to you for a while.
Great. So again, I'm not an expert in all of these applications, but having done some research and having been a user myself, there are certainly some interesting points that might be helpful for people to understand either personally or in their business life. From my perspective, messaging has always meant more than the texting, the messaging apps as we call them now. I would include electronic mail in messaging from my information governance experience. But let's break these into some separate components here. So SMS, the short message service, most people would remember that from using the old flip phones before all the apps came into place. The common service providers had the ability or gave you the ability to send text messages of up to 160 characters to individuals all over. What we've moved into are what they call the over-the-top messaging applications, and you see the WhatsApp and the WeChat and so forth. And they have instead of using the carrier service, they're actually running off the internet, and they are enabling the use of audio, video, graphics, and things of that nature that you can add to your text messages. So it becomes much more rich. In addition, what's coming next, I think, is something called Rich Communication Services, RCS. That's going to become a standard. That's really not too available now. But I think when we talk about some of the virtual messaging platforms, you can start imagining where we're heading with some of these capabilities.
So should we talk about benefits and risks a little bit?
Yep, absolutely. You want to add to that, Ron?
No, I think as far as where we are now, we have a number of options available to organizations as to what they want to use or not. One of the challenges I think we're going to be facing in the future, and David, I know you're going to talk about this later, is when some people decide this platform is an excellent one to communicate with, but it's not within a formal structure approved by an organization. And that I expect is going to create any one of a number of challenges as we go forward.
Absolutely. I agree with that. And one that I can think of, what I was referring to earlier, we've got these capabilities that come with your iPhone or your Android, or you can use one of these tools like Facebook Messenger or something like that. We've got a couple of interesting influences. One is that WhatsApp, most folks are probably familiar with, its end-to-end encryption is attractive to folks. Well, with the purchase by Facebook, there's an expectation that that will change. And then, of course, there are capabilities that some of these companies are building into these applications to make it business friendly. So as an individual, you may want to use WhatsApp and say, it can only be read on my phone and the person I send it to, and in between it's encrypted and nobody can read it, period, end of story, unless you have that mobile device. Well, my understanding is Facebook is expecting to make it available to businesses so that businesses, and essentially what would happen is a business would implement some servers and facilitate the distribution of those messages and have an ability to capture those messages if they need to. An interesting point with the SMS messaging, if you're using a non-smartphone, an older phone, or an SMS service that's managed by Verizon or T-Mobile or what have you, they do not capture the content. They know you sent a message, they know when you sent a message, but they cannot turn over the content of that message because they simply do not have it. So that's something interesting that I found out recently. And then from another business perspective, again, a number of financial industry firms got together and decided that they wanted a certain capability that is built for their traders and their communicators to their clients. And they built a program called Symphony, which has a tremendous amount of capability in terms of chat messaging and other communications and sharing research and things of that nature. And it's quite robust, but they wanted to have that themselves. And then from a regulatory perspective, and we will talk about this a little bit more, there's also the question of how do you preserve those messages? So that's critical. And actually, that's probably a good intro to the next slide. Messaging, which essentially what we're talking about here is that a message can be fully deleted at some point, whether it's a clock that's set or something that you can manually address. So WhatsApp, for instance, if you're familiar with it, you can send a message to somebody and you can actually, after it's sent, delete that message and it'll ask you, do you want to just delete it for yourself or do you want to delete it from both the sender and the receiver? And you have that capability. And certainly there are concerns with that, but the fact that it's a mobile to mobile transmission means that also when it's encrypted, it can't be read by anyone else. And maybe somebody, if there are some questions here, we'd be happy to take some questions if people have some points to raise about the tools that they use. I've not used Telegram or Signal or some of the others, Snapchat, Confide, Frankly, Wicker, Blink, Cover Me, Hash. I mean, you can go on and on. There are so many tools out there right now that have their niche in this space. They're all driving at the same thing. Fast, quick ability to send a quick note to somebody that persists for the time that you want it to persist and then goes away. And here's something that I found interesting. In terms of the legal space, there was an application called Dust, originally called Cyber Dust, if people know an individual named Mark Cuban, a very wealthy owner of lots of companies, including the Dallas Mavericks. He created this application specifically because he went through a very onerous legal process, and he actually decided to invest in this company just so that they had the capability to destroy messages that could no longer be found. And I'm not saying it was for nefarious purposes. His purpose was simply because there was too much stuff to review, and it ends up being useful in other ways that are not necessarily pertinent to the matter at hand. So he actually invested it. So there's reasons for having these types of applications, even from a business perspective. Certainly that's not addressing the legal hold question if there's a legal matter at hand. But certainly that is a business driver of doing this, reducing the e-discovery impact. And of course, from a data security perspective, if you don't have the information, you can't lose it. So there's an argument to be made about cybersecurity as well with some of these capabilities. I cover that, Ron?
I think it's fair to say, David, putting aside the fact of whether there should be a record made of a communication in the first place, if you look at the privacy laws that are in effect, and in Virginia, for example, may be going into effect if the governor signs it soon, there's this concept of minimization. So maybe you have information, but at a certain point in a life cycle, it's time for the information to go. I don't think that's inconsistent with anything you said. The only problem with that is, do you have some type of obligation? Well, look at this. Do you have an obligation to keep something you've made, depending on what the information is? And then you have the issue about the litigation hold that may come in the future. So I think these are all things an organization needs to consider when it's looking at using these different platforms.
Absolutely. And switching over to the virtual meeting platforms, there's some real interesting developments in this space. And I think there are different perspectives on what we're using these for. In some cases, I felt for a while it's the advent of the video phone, essentially. I do tons of video calls these days as opposed to using a phone or just texting. We're always just popping a video capability into a chat message, and people are clicking on it, and it launches in Google, and off we go in our conversation. Very, very helpful as a video phone, essentially. But then there's, of course, the conferencing capability. You can have lots of people on a call at the same time and see the videos all at the same time. Very helpful, as people know, and there's lots of tools that do that. Where we're going to, though, and I found this extremely interesting, there are some tools like Kumo Space and Pluto that are actually creating environments. And essentially, you can connect to a conversation happening in this environment. And if that conversation is no longer valuable to you, in this space while you're online, you can actually move to another conversation. Think of it as essentially a business space, a floor in a building, and you could be in a conference room having a conversation, but you know that there's another meeting going on. You can virtually leave that space and essentially walk over to a social space, an office, another conference room, and join another conversation. You can think of it another way as kind of going to a party. People use these for social instances as well, where essentially you kind of walk in a front door and you can have a conversation with somebody who's there, but you can move around a house and join different parts, different conversations that are happening. And they're essentially little breakout rooms, but you can just walk around and join them, and they get louder as you get closer and they get softer as you walk away. So the technology is really getting quite interesting. And Pluto, for instance, is one that allows you to create your own virtual world. So all these capabilities sound like great fun. I think we're going to get into a little bit more about benefits and risks, and then we'll get into some of the legal conversation as well, which is quite challenging. And of course, how do we handle this from an IG perspective? What do we need to keep? Some thoughts, Ron?
Well, I think in the interest of time, we should just go on to the benefits and risks specifically, and let me chat about those for a few minutes, David, with you joining me. And we're looking at ephemeral messaging here as a double-edged sword, but I think this also applies to virtual platforms. And I don't see any reason why we can't think of these for these purposes together. Automated destruction, David, as you mentioned, the content of these messages can stay for a period of time, disappear immediately, or whatever. That's something to think about. That's good unless you have some obligation to keep the content, or even some of the metadata, if you will, as to when messages are sent and received and the like. Then we have the confidentiality concern. Obviously, that's an issue. If I'm your attorney, David, and you're my client, and we're communicating through ephemeral messaging, there may be reasons why I would want to keep that information, but there's certainly reasons why I want to keep it confidential, to preserve privilege. And that's something to be concerned about, obviously, to avoid interception. Same thing with virtual meetings, by the way. You and I can have a virtual meeting as attorney and client. We don't want a third person listening in to us. And then last, thwarting law enforcement, that's a topic all by itself. But if there's conversations going on, for example, and the conversations are between salespeople, and it turns out there are antitrust implications of that, government might want access to the content of ephemeral messages or virtual meetings. And then the question becomes, what do you do about that? And do you cooperate with law enforcement if law enforcement wants information? And are you going to respond to subpoenas and the like when they're served without any type of challenge? So, David, I think it's fair to say this works for any type of virtual meeting or any type of electronic communication, if you think about it.
Yeah, absolutely. And I don't want to jump the gun here, but the question then is about cooperation with law enforcement. Most business organizations and individuals, I think, would, but what about the forcing of a carrier or a third party being pressured to produce information? And I guess it depends. I'm not sure what the legal view is right now on all of those things.
Well, one of the issues that I think anyone with in some type of an organization will be confronted with, or may be, if you're served with a grand jury subpoena or an order or whatever, and say, give me the information, but don't tell your client you're giving it to me. If nothing else, that raises some PR issues and governance issues for the organization. But again, that's something I think we can talk about at another time. But it's a legitimate concern, something to think about. Well, let's look on the next slide, talk about the benefits of well-governed programs. Obviously, a program needs to understand the nature of the communications, how to protect them and the life, safeguard them. This next one's interesting. How do you facilitate a communication without requiring or maintaining a record of every digital exchange? That's a governance issue as to what you want to keep or not keep. Retention periods, I touched on that before with regard to this idea of minimization. Unauthorized destruction. If two employees are having an improper communication, let's assume it's sharing child pornography. There may be a reason to preserve that for law enforcement purposes until that investigation or the like is over. We have to comply with data minimization, as I mentioned before. That puts us, David, right into the scope of these data privacy laws, and I'm sure you can speak about that more than I can. And last, we have the data security risks. So there are a lot of things that a program is going to have to focus on when you're dealing with ephemeral information. But David, same thing with virtual meetings, right?
Absolutely. And I think you hit the nail on the head with the management comment. So the governance of a program, and I'll talk about this in a minute, but the governance, the policies and procedures, the ability to enforce and control and so forth, that's going to be critical.
Well, let me just run through these lawful applications very quickly. You see, we've got GDPR that some of your organizations may be subject to if you're getting personal information from European residents. The New York Shield Act, I'm guessing a number of you are New York regulated. But this is an interesting statute because no matter where you are, if you keep defined information of any one person who's a New York resident, you're subject to the statute. And if you're a financial services organization, you may be subject to DFS. And then we've got the California statute. We don't have time to talk about all of these things. Just bear in mind that none of these prohibit what we're talking about, but they do impose requirements for security and the like that you need to think about if you are subject to any. So, David, we can go talk about the next slide, or any comments here?
So I think what this slide really talks about for us is the risk factors being, there's certainly financial risk if you're highly regulated. There's certainly the compliance risk that you need to be concerned about. There are internal productivity risks and so forth. If people are not following rules and potential for negative technology. But I think the one that concerns me most frequently and impacts a lot of the others are the reputational issues that can come out if you're not managing the program properly. In some cases, it can be extremely negative, and in others, it might be passed off. But I think this touches on all of those, including, and I love the point about the creation of shadow IT. That's a real problem, and I'm going to throw out this story if you can bear with me for a second. So actually, I knew some gentlemen many years ago who were playing golf. These gentlemen happened to be traders for very well-known financial firms. And you just have to be careful about these things. Not only do we have the ability to use different technology on our own applications, but an individual actually had to complete a trade, but he didn't have his phone with him. So he used another individual's phone to communicate with a client to complete a trade. And for those of you who are familiar with the financial services industry, that is an extreme no-no. So those types of things do happen. How do we prevent those? That's more of an awareness and training, and how do you capture those things after the fact? But there are a lot of significant risks that we need to be concerned about.
Well, we have less than 15 minutes left. Why don't we look at business records and the like a little bit?
Yep.
About
Okay.
rules, and then we'll
Yep.
turn it over. Give me 5 minutes to run through these, and then we'll turn it back to you. Business records, we all know what records are. We know how they are defined. We know what documents are, and documents can be broader than something that's a record within an organization. You need to be concerned about that, because whether it's a record or not, if there is some type of document, electronic or not, that an organization has and it's subject to a duty to preserve, you've got to hold on to it. And this one decision you see here talks about a duty to preserve text messages of key management personnel. And then we have the management of non-records. And David, this goes back a little bit to what you mentioned before. This may have to do with shadow IT, and it has to do with collection of information that you may not know you've got. So let's talk about scope of discovery a little bit. This is pretty simple. Some of you have probably been involved in litigation in federal courts. This is the federal rule about scope of what you keep or what you're required to produce in discovery. States may have small variations of this, but basically it's anything relevant to a claim or defense that's non-privileged. And then you see the rest of this quote talks about so-called proportionality principles. That means that effectively you've got it, but you may not produce it because it costs you too much time and effort to do one way or the other. And then if we go to the next slide, this is probably the most important thing for all of you. This is the idea that if the information's relevant, I, as a party, can go to David and say, David, if you've got possession, custody, or control of electronic information, give it to me. That may mean that you're maintaining information with a vendor in the cloud, but if you have control over that information or access to it, you may need to produce it in response to a document request or a discovery request. And then, David, let's go on and look at some case law just a tiny bit. Discovery of ephemeral communications. These are some questions that you might want to ask, both as to ephemeral communications and as to content of virtual meetings. Is it recorded? Is it relevant? Is it not privileged? Is it proportional? I mentioned that before. And possession, custody, control. So this is kind of a checklist that you might be able to use when you're talking to your lawyer about whether information exists or not. The big question, of course, here is, if it's disappearing, do you have an obligation to keep it? And we're not going to spend too much time on that. I'll leave that as a tantalizing question for another program someday. The next slide, if we could, talking about storage of messages. This is an app that's come up and saying we're keeping it for 7 days. So if you keep it for 7 days, that means it's stored. And it may be subject to a duty to preserve in litigation. This has a lot to do with the platforms your organizations keep or your employees use. And the next slide, just evolving views. I'm not going to go into these. You can read them when you want and take a look at what they say or mean. Next slide, David. This is a famous decision about whether there's an obligation to keep oscilloscope readings. This is the Convolve case versus Compaq. You don't need to keep the little squiggles across an oscilloscope for any one of a number of reasons. And then there's a decision about keeping RAM, rapid access memory, whether that's within the scope of discovery or not. And the answer to that is yes. And then we've got the Waymo decision. That's pretty recent. It's from 2 years ago, 3 years ago or so. This is a question of using ephemeral messaging apps. And a court allowed information to be produced as to whether or not that was used and what the effects of that might be. And then we've got the Herzig decision, not even 2 years old, out of Arkansas. This is some people decide to use a messaging app to communicate back and forth after the duty to preserve attached. And you'll see the court did not like what was being done, but granted summary judgment for a different reason. So we're starting to see some case law on this. David, not that much, but maybe you want to talk about what the regulators are doing with regard to this stuff.
Well, from a broader perspective, one of the things that I see the regulators doing these days is that the fines are increasing rapidly. We did a search recently on a client who is a very large client, but I was pretty shocked to find out that in general, they've been fined over $25 billion over the past 20 years. And certainly all of those issues were not the focus of a records management issue, but certainly all of the related factors that go into such regulatory issues. And certainly some of those regulatory issues dealt with basically information governance concerns. And some of the things that we're talking about here, I think will come up more and more. And certainly folks, organizations are getting much more concerned about the advent of all the privacy requirements. So growing concern everywhere, and people need to address these, organizations need to address these issues as they're increasing.
And you see this came out of the Department of Justice. This is guidance for Foreign Corrupt Practices Act. And you'll notice the references to messaging platforms and the like. So these are concerns that I think regulators are going to be looking at in the future. And if you go to the next slide, David, we have guidance from the Antitrust Division. And this is another issue with regard to using these different type of applications. And if nothing else, David, we'll go back to something you mentioned before, and that may be how the public or how investors perceive, or the regulated community perceives, when there's an investigation being done and there's a press release from the Department of Justice about the use of these technologies.
Certainly.
Stuff.
It really is. And it occurs to me one of the benefits of some of these tools is the ability to control where the information goes as well. So it's not just the ability to destroy it, but control the ability to forward information, as a matter of fact. So that's important as well.
And here you see with FINRA and the SEC, again, we see regulators weighing in on keeping records, what the record should be, how the record should be maintained, and the like. And of course, the SEC saying it may not be the best idea to use something that disappears information that we need to be able to see what the regulated industry is doing. Correct, David?
Absolutely. And as I mentioned, in this industry, a specific tool was developed to facilitate business, but also allows the partner firms, this application called Symphony, to manage that information effectively. And if folks are familiar, lots of industries use Thomson Reuters or Bloomberg or other reference capabilities. And certainly if you're using those applications, they have chat messaging and email and other capabilities where an organization will need to maintain that information, either because there's some notion of a business record, or if there is a legal or regulatory matter that information needs to be retained. And then how do you do that? And we'll talk about that in just a minute. We have a couple of slides left. We do want to leave a couple of minutes for questions. And I see one from Jenny here. When do you think there will be a federal standard for information governance rather than just on a state by state level? I wonder if that's a privacy related question. Jenny, if you want to throw that one in there, go ahead, Ron.
I think effectively, don't hold your breath waiting for the federal government to do something in this space. There have been a number of bills introduced in the last Congress. There's legislation being proposed in this Congress. I think realistically, you're going to see stuff at a state level. I know that entities would like to have some uniformity across the country. If we do have it, David, I don't know if we're going to be seeing a comprehensive statute such as California has now, or New York has, or Virginia may have, or Washington State also may have, because there's legislation pending in Washington State now. It's been up before to create a privacy law, if you will, that includes cybersecurity in it.
Do you think there is a regulatory body or a regulation out there that seems to be appropriately comprehensive that people should focus on? If they focus on one or two, will they be able to address many or?
I think the biggest concern that organizations have, frankly, other than complying with these laws, is what are the penalties going to be if you violate the laws? California has a private cause of action. New York does not. Virginia, I believe, is not going to have one. It's going to be enforced by the Attorney General. I guess the scariest area for anyone comes under the Illinois BIPA, which regulates collection, storage, use, whatever, of biometric information, biometric identifiers of individuals. The Illinois Supreme Court has allowed a private cause of action there with attorney's fees. Some of you may know Facebook just had a settlement approved for, David, I believe $500 million in the last few days because of that statute. So is there one baseline? I suppose the simplest baseline is from the FTC Act that says don't engage in deceptive practices or misleading practices. So don't promise security when you're not giving it.
Yeah.
But beyond that, there's so many different ramifications to these laws. I'd like to say there's one, if you comply with one, you comply with everyone. We can have a conversation about that for an hour or two someday.
And the last comment I'll make on this, from a governance perspective, I'm thinking that some of our bread and butter here, right? You've got to have governance, your policies and procedures. You've got to have tools, training, awareness, and all those things that are kind of motherhood and apple pie to us. You've got to have those. And as the tools and the regulations changes, you've got to maintain these things. And that's been a problem historically. But my biggest point about this right now that I can think of, Ron, is that there are a tremendous number, as I understand, of privacy inquiries around the world right now that are unfulfilled, that are going to these data privacy councils around the globe. So my concern is that at some point, the regulators, as they have with certain industries in the U.S., will start ramping up, and they'll realize there are so many violations, there's so many issues that they will start resourcing and the fines will go up, and you'll hear more and more about this as time goes by. They're trying to figure out what organizations can bear, and trying for some level of fairness and matching capability to that.
I think we need to look at California, putting aside the GDPR. I think we need to look at California along the lines of what you're talking about, because the new California statute, which just was adopted last year as a result of a referendum, has created a separate privacy officer for the state. So it's taking some enforcement away from the Attorney General, as I understand it. So we'll see how that ramps up.
Yeah. Very good. And I think it's time for Q&A here. I think there was great coverage in lots of spaces. Some of them were a little bit lighter. So we want to open up for questions, comments from anybody on any aspect of this conversation. Do we have some questions?
And I wanted to try to get us through every slide, which we did, David. So there's information available here.
Well done.
for folks. Yeah.
And this will be available. I know there's been questions about our presentations going to be available. The recordings, if you hadn't heard, the recordings will be online and available to registered attendees for 90 days. I expect most, if not all, of the presentations that have been given will be posted as well.
So I guess we're out of time, David.
Right on time, actually.
Very nice. Thank you both, Ron and David, for your time and insightful discussion. We really appreciate it. And now I want to remind everyone that we would love to see you at the networking and trivia game event that starts at 5 o'clock. We'll actually be able to see each other and interact, so it should be a lot of fun. So we hope to see you soon.
Anna,
That
thank
will be
you.
fun.
David, thank you.
Thank you, Ron, and thank you to Archive 360 for being one of our good sponsors.
And thank you, Archive 360. Okay.
Thank you.
Enjoy the virtual cocktail party.
You should join us, Ron. It's going to be fun.
Right.
Exactly. Thank you all. See you soon.
Goodbye.
Bye.